It can be quite scary when expectant parents learn that their baby may be born prematurely. In the 2003 Texas case of Miller versus HCA Incorporated, we examine one couple's nightmare in which this news was only the beginning. Karla and Mark Miller were expecting a child in December of 1990. However, Karla was admitted to the hospital in August in premature labor. The doctors initially tried to stop the delivery because the fetus was only 23 weeks old. However, they later learned that Karla had an infection that was potentially life-threatening and may require them to induce delivery. They let the Millers know that if they did have to induce delivery, such a young fetus had a small chance of being born alive, and if it was, it would likely suffer from significant impairments. The doctors then talked to the Millers about whether they wanted treatment administered to the infant if delivery was induced and the child was born alive. The Millers responded that they didn't want any heroic measures performed on the baby and rather preferred for nature to take its course. The hospital's neonatal director later notified Mark of the hospital's policy that required resuscitation of any baby who was born weighing more than 500 grams. To avoid making any decisions prior to seeing the baby, the hospital team agreed that a neonatologist would be present at delivery to evaluate the infant's condition and determine whether to resuscitate. However, Mark refused to sign the resuscitation consent form. Karla's condition later worsened, and the doctors determined that they needed to induce labor to avoid further health complications to her. The Miller's daughter, Sydney, was born alive and weighed 615 grams. She had a slower than normal heartbeat, was blue and limp, and gasped for air. Other than being premature, however, Sydney displayed no deformities. Because the neonatologist determined that she had a reasonable chance of living, Sydney was quickly intubated and placed on ventilation. Neither parent objected at the time, and Sydney initially did well. A few days later, however, Sydney experienced a brain hemorrhage, which caused severe mental and physical impairments. The Millers later sued the hospital's parent company for battery and negligence in trial court. At the time of trial, Sydney was 7 and unable to walk, talk, sit up, or feed herself. Amongst her other disabilities, she was legally blind with significant mental impairments and cerebral palsy. The jury determined that Sydney's resuscitation without the Millers' consent was negligent and proximately caused her injuries. It awarded them over $60 million in damages and prejudgment interest. The appellate court reversed, finding that the Millers couldn't have denied Sydney medical treatment under these circumstances. The Millers appealed.